My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate the public, so please subscribe to our channel. Today we're going to talk about how to safeguard your children from risky activity proposed by your ex. So here's the scenario. You split up, you have kids. Sometimes the kids are with dad, sometimes the kids are with you, whatever. And dad wants to take the kids to something that you feel is risky. In the summer, there's certain activities that people sometimes feel is risky. Boating things, activities on the water, tubing. I've heard people complain about that. They don't like when the kids do that. And it could be other things, or it could be jet skiing or anything like that. So I think if you're in that situation where you feel that your ex is going to take the kids on something that's risky. Now, of course, the kids want to go. You know, they always want to do those kinds of things. For them, it's like a thrill thing. It's like you see a roller coaster, you might say, well, why would anybody go on that? Well, kids, they like to go on those things. So number one, you're going to have to assess what the risk is. Is it a true risk to the well-being of the children? Or is it simply something that's ultra-recreational that's beyond your comfort zone? I want to tell you one thing. You know, if you feel it's a true risk and you've made that assessment, you're going to spend money on lawyers to file motions. They're going to get before some judge. And for all you know, that very activity may be something that the judge himself loves. It could be something that he or she engages in on a regular basis. It could be something that they just did with the grandkids only the day before. So in other words, you've got to assess, is this a true risk? Or is it simply a question of your comfort zone? Because if it's just a question of your comfort zone, save yourself the couple grand that it's going to cost to do that kind of work, to file these motions, to have these things before the judge, because it's not going to work. You're going to have to expand your comfort zone, you know, to allow certain activities which, while you may define as risky, you may be surprised, and your lawyer will tell you whether or not the court defines such activities as risky. A lot of people define skiing as risky, and yet when I take my kids skiing, the most, what I deem treacherous mountains are full of kids snowboarding down them. You know, on their own. They look like 8 or 9 years old. I can't believe it. It's just not considered risky in everybody's definition. You have to, secondly, communicate those concerns to your ex. Is there a way that maybe there can be something done to bring it back within your comfort zone so that it won't be risky as you define it? So you won't have to go to the court and explain to the court what may very well be an activity that the judge herself engages in. So it's important to communicate that. You should, of course, familiarize yourself with your legal options if the communication fails. And what does that mean? Talk to your lawyer. Find out, is this really risky as defined by everybody, or are you being a little bit over the top on it? And if it really is risky, or it's at least arguably risky, then what are the chances are that you will prevail? Once you discuss this with your lawyer, then you'll have a better understanding of what to do and whether or not this is something you should go forward with. Now, if you have any questions about that, reach out. We'll be glad to help you out.